Unfortunately, as a judge, you don't get to work with the kids. And I think that in family court cases, many times the courts don't look enough at what is in the best interest of the kids.
Alex here with a Perspectives video on Best Interests of the Child. Donna Wilburn, a licensed marriage and family therapist with Red Rock Counseling, is going to be interviewing family law attorney Carrie Molnar, who is running for Department Y of the 8th Judicial District Court.
Hi there. So I'm Donna Wilburn. I'm a marriage and family therapist, and I've worked in the field of the forensic, helping out with court for, gosh, at least like 15 years now. It's kind of how it's been. So as I have been working in this field, and I've noticed that we have, what do we have, like 20 judges and maybe a good 10 new ones or something. There's like a lot of seats up there that folks are getting elected for. So even though I've worked in that field, I don't know a lot about the candidates. So the reason that I'm even doing this is because I wanted to get to know the candidates and be an informed voter. And I figured folks out there would want to be informed also. So obviously my field is mental health related, and that's what I want to know about, right? So that's what was important to me for this. So I am just like, whoever wants to come in and share information, they're welcome to do that. This is not, I don't pick people to come in, but I'm going to be talking about mental health and specifically high conflict divorce because that's the crowd I work with. Okay. So why don't you introduce yourself, what seat you're running for, and why you would be a good candidate for someone to vote for.
Sure. So my name is Carrie Molnar. I'm running for Family Court Department Y, which is a new open
Is it?
seat.
It's a brand new one.
It is. So what they did was we had 20 departments, and the letters are just letters to which judge you're assigned to. People don't always understand that.
Yeah, I thought it was just like alphabetical something.
They are,
Okay.
but then the cases get like randomly assigned to a department, so it kind of goes with the letter and the judge that you're assigned to.
Okay.
So they had 20. They opened it up to 6 new seats, and then there's several judges that are retiring and that aren't running. So there's open seats in a lot.
So how many are going to be elected? How many seats are going to be filled with this election?
26.
They're all 26 are going up, but some are not opposed.
But some are unopposed. And
Okay.
I believe there's 3 or 4 unopposed. So the judges that are currently in those departments will stay.
Right.
And then the remaining are either with an incumbent, which is a current judge, or they're just attorneys that are running for a judge.
And so you said Department Y, and that's a new seat.
It is.
That doesn't have an incumbent yet.
It does not.
Okay.
It does not. It's a completely new department. So we had, I believe it was up to T, prior A to T.
Okay.
And now we're doing all the way to A to Z.
Wow. So we have a Z now?
Correct.
Oh my goodness.
Yes.
So one thing I want to say before you give like why you're a good candidate for someone to vote for is that as a judge in family court, and this is why I take it so seriously, the judge makes decisions that affect children and could affect their whole lives, their brain development, everything. So when voting for the judge that you think would best help families, the more information you have them, the better. So that's why I am taking this so seriously, is because these positions affect children. And if you make half-hearted decisions or uninformed decisions, those kids are the ones that get affected. So I say, like, take who you're going to vote for seriously. So when you're going for the bench, why should someone vote for you?
Well, so I've been practicing for 15 years. I took this Florida bar in 2005 and started practicing out there and have specifically focused my practice on family law.
Like the whole time?
The whole time. I've done a few criminal cases here and there, maybe 2% of my practice. But most of those cases have involved domestic violence, batteries, something with family.
Still family
more or less. Yes. So other than that, it's been strictly family court. And I think that a big thing with elections is we have, in the family law arena, there's a lot of people that have never done family court or family law that run to become a judge in the department.
I hear it's a whole different animal.
It really is.
Family court is a whole different animal.
Family law, some people claim it as a specialty division of the court, the district court. So with our election, it's all of Clark County. People don't seem to realize that either. So anybody in the whole county can vote for the judges.
Okay.
But with family court, it's a special area. So there's a lot of intricacies and a lot of little things, especially like you said, dealing with children, dealing with families, that if you don't have a lot of experience in there, I personally would not want to go in front of a judge that have never done that they don't know the specific case law. I mean, there's general cases, and then there's nuances, even for divorces when you get outside of the custody aspect. So I really believe that with family court, it helps to have somebody that's been doing it, and doing it, focusing on every aspect of it, not just limiting a focus to maybe we just focus our practice on abuse and neglect, or maybe we just focus our practice on domestic violence, or maybe we just focus our practice on guardianships or adoptions. You need to have the wide range because you're making decisions on all of those issues in different cases.
And even in the same case, those issues can come up at different times.
And that's why a lot of family court issues, I think they have to be taken on a facts and circumstances of each individual case. Because you can have the same types of situations that occur repeatedly in family law, but you still have to look at the facts and circumstances. And my favorite area of family law has always been custody and dealing with the kids. Prior to going to law school or anything, I worked with a lot of different youth groups, and I worked with kids that were put into youth groups that either came out of the criminal system or out of the foster care system, and they were placed into group homes. And so we would have to sit there, and the relationship that you can build with kids and the trust, once you have that trust, you have a kid, they'll do anything you ask them and please you or whatever. Unfortunately, as a judge, you don't get to work with the kids. And I think that in family court cases, many times the courts don't look enough at what is in the best interest of the kids. And from the child's perspective, that kind of totally goes by the wayside, because you have two parents that are fighting and don't even like each other at that point. And they're coming in trying to determine what's in the best interest of the kids when they can't make good interest for themselves or good decisions in their best interest because they're so upset.
I'm thinking they're not like the most logical, rational place.
A lot of times they're
much
not.
less super empathic to what their child needs because they're so emotional.
Exactly. So my perspective on this is to take more of a broad look at what has the family been experiencing and what are those children used to. Because as an attorney in Clark County, since I've been out here, and I've been out here since 2007 and doing just family law, I've been appointed several times at different times throughout my career out here to be appointed on abuse and neglect cases through Clark County, which is where the kids are being removed from parents into foster care and possibly termination of parental rights. And the thing that always interests me is when you would get to talk to those kids, or some of them would send letters, and it was for a child to be taken away from their parent. They don't care if they have the best parent in the world who's providing them $1 million worth of gifts and things every year, or if they have the parent that has issues that they are not able to get the help they need or control those issues that are making them not be able to make best decisions. But from the kid's perspective, that's their mom and dad. Don't take me away from my mom and dad. So I think a lot of times with family law cases, when somebody has a substance abuse issue and a mental health issue, or a mental health issue, and I think those go together hand in hand. I really do. I really, really believe that. I think that the worst thing that a court can do, I know that the judge's job is to protect children at all costs, and that's something that
That's what I thought it was.
truly believe in. But at the
So
same
child's
point,
best interest is the priority.
that is supposed to be the priority, and that's one reason that I'm running, is for custody issues and for kids. Because I don't think they don't come in, they're not witnesses. Hearsay is not allowed, it's kept out because of evidentiary rules.
But the adult hearsay seems to be allowed.
The stuff that people say about their kids, and nobody really gets to talk to those children. So I think that in family court cases, more guardian ad litems and attorneys for children should be appointed. And I think that, again, when I've done consults for the last 15 years, people will come in and they'll say, well, the other party has a mental health issue, the other party has substance abuse issues. At all costs, keep them away from my child, right? Which is big, huge problem there.
It's a little flag.
But keep them away. And then you ask them, well, what have you done to protect your own kids from those issues? Because why, if that other parent that you're coming into my office now, claiming that they cannot be around your child or see your child or talk to your child, where were they? Did they ever spend the night with these kids? Did they care for these kids? And were they having those issues at that time?
Right.
So that's
Why now
something,
you saying
right?
children? past 10 years.
And
you
that's
said.
something that people need to really consider, because if you have stayed together with this person for 7 or 8 years or more, and you've allowed them to take full control of those children, to watch those children have overnight visits, take them out of the house unsupervised, do all this stuff, why now? It's just because you're filing with the court. So there's issues there.
That's
So
interesting you even look
it
at
is.
that. They even question that.
It is, but it's true.
Yeah.
And so I think from the court's perspective, and what I intend to do if I'm elected, is to really look at how can you keep the most contact between these parents and these children, so that you're not causing another negative effect on this child with a separation or a divorce case, but protect these children at the same time, whether it's to bring in therapeutic services, have somebody in there supervising them. But I don't think the ultimate decision is you have an issue until you get it resolved. You don't see a child.
I know.
Not at all.
It's almost hurtful to see these kids go through something like that. And I like that you said keep the contact, but yes, attend to the issues and find a way to have contact that's still safe.
Right.
Don't make these kids have to have no contact and,
Correct.
while you even look at something.
And another issue, because you don't have to.
Right.
And the kids don't have to be so negatively affected.
Mhm.
Another issue I wish that parents could get over is if there is a parent with something going on in their life, either an addiction that they voluntarily got involved in,
Mhm.
or a mental health issue, which sometimes they have no control over those. And again, sometimes they're hand in hand, because maybe there's an underlying mental health issue that never gets diagnosed or taken care of. So they turn towards drugs to try and
Like
cope with
self-medicating,
it.
right.
Correct. And so a lot of times that mental health issue never gets brought up. Nobody ever even realizes it. They focus on the addiction of the substance. But I think if that other parent that doesn't have an issue could be more willing and open to keep and maintain, rather than putting that other parent down to those children, I think that the children long-term effect may be limited or not at all. So I think a lot of it has to do with how the two parents, especially the one with no issues that's coming in, handles the entire situation.
So, as you're talking about how it's called co-occurring disorders when one disorder creates another disorder. So I don't know, if this statistic came across your path, but there's a statistic out there that maybe 90% of, or, probably not 90%, but quite a large percentage of people with addictions have untreated ADHD.
Correct.
That's a component. And ADHD factors can be genetic. So what you're punishing a parent for not getting treatment, they didn't even know they have it. They, like when they were young, no one realized it. And now they're self-medicating with addiction. That same underlying disorder could be something your child's working with.
Exactly.
So they need almost like support. They need a healthy parent, but they also need support in the mental health aspect of what the child is going through, which I have ADHD. My parent has ADHD. They coped with that. In that way, that's bad. But I need a healthy way to cope with it rather than they're horrible, terrible. That's one of their disorders, but you're okay. That's going to be really hard for a child to feel comfortable with. They will not be comfortable with themselves if they have that similar situation.
They won't. And there's a couple issues that stem off that, because one thing that I've always done in the 15 years that I've practiced, and when people come into my office, I will ask them, do you have any issues? Do you have any substance abuse? Have you had any mental health? Do you have concerns? Any mental health issues? Because a lot of times a depression will set in when people separate and are going through this. Their whole life is being destroyed. It really is. They're losing friends. They're losing family. It's a horrible area. So you really want to know, is there anything that you're maybe thinking of doing to yourself to harm you, to try and get them help? Because I always tell them, if you have an addiction of substance or alcohol, if you have a mental health concern, be the one that lets the court know that to get the help you need. Because it does you no good to go in and file motions and start cases and try to avoid it, thinking you're not going to look good enough in front of the court. And then you let that other person bring up all this bad stuff about you, and then you have to respond to it. So the best thing to do, it's okay to not be perfect and okay. But the court can help you if they're aware of the situation. But to have somebody else come in and bring all this in, and then you have to stand there, and then the judge is looking at you and saying, do you have a substance abuse issue? Do I have to drug test you? What are you going to come out at?
Like, let's be honest.
Yes, if you're up front, there can be a lot better ways to resolve your case
Right.
and your issues and get good orders, rather than have a judge think you're hiding something
Right.
or lying or something
So
like
here's
that.
here's a question. As a mental health person, I hear clients come in, right? And
Mhm.
let's say they are getting a divorce. They say, I don't want to tell anyone that I'm in counseling or that I'm on medication, or
Right.
what if someone finds out that I am, and then they're going to think I'm a bad parent. So from the court point of view, if you're up there, what would you think of someone where they do say, I'm in counseling and I'm on medication and I'm disclosing that?
Well, here's one of the reasons I'm running is because in 15 years of sitting in court and meeting people and hearing a lot of different issues that have arisen in people's cases, the family court is a very difficult court system because it doesn't automatically grant you an attorney, okay? So it's one of the only areas. Criminal, you get an attorney. If you're in abuse and neglect, you get an attorney appointed,
Right.
okay? Family court, you don't. So here's what we have. We have many cases where one side of the case, especially more in divorces than just custody, has the money and takes off with the money. So they're leaving somebody at unequal footing to have an attorney and have representation. And so what you have to do is, my goal is to let everybody know whether or not you have an attorney, you're going to get an opportunity to be heard. It's going to be a fair opportunity. But yeah, if you need the help, it's okay. Come in and admit that you're not okay, because it's better. You can take baby steps in litigation, but if you admit that you have an issue and the court can help you, they can start you out on a supervised visit or something to protect the children at all costs, but build you up so that by the time your case is over, you're at that same point of maybe equal custody, if the kids are protected with it.
Right. So I work in high conflict cases, and high conflict tend to be where, they're uncooperative with each other. I say there's two different kinds of divorce, a cooperative one and a high conflict one. And the cooperative, they talk to each other, they can, negotiate dilemmas, or, doctor's office, they can be in the same room together. But in high conflict cases, one or more may have a personality disorder or some other factor, the extreme hurt, extreme emotions, they can't even be around each other. So I consider them two totally different operating systems, okay? So I as a forensic provider, I tend to work with the high conflict ones because the other ones don't seem to need a therapist involved, they're fine. In high conflict cases, certain themes come up a lot, right? And one of them is visitation refusal, where a child is just refusing to go to the other parent's home. You don't know the details of it until you really look underneath it. It could be anything from I got grounded to they're abusive, right? So in visitation refusal cases, like, how would you handle that coming across your path? And then how would you, let me let you answer that one, and then I have a follow-up one to that. So how would you handle a visitation refusal case?
Okay, so as you're talking, a lot of the low conflict cases, the court's not going to see either.
Oh, right.
Because those parents
They're
resolve
fine.
things.
Yeah, they can talk to each other.
Right? So when you get high conflict parents, I think a lot of it is you have to really look at, and again, that's why I would do more referrals out with children, to get somebody in there to really look at what's the children want and why they want it. Because you have many, like you said, depending on the age of the children, some kids hit that teenage and they're going to conflict with both parents.
Sure.
Or one or the other.
Call
You
it
say
hater
bad
mode,
things.
those teenagers.
I'm running to dad's. And then as
Yeah.
soon as dad says one thing negative or punishes them, I want to run back to mom's.
Right.
Well, there's a point. The court right now doesn't have where kids can come, and there's no age in Nevada that says, a lot of people think it's 14, a kid gets
I know, that was
inside.
one of my follow-up
No.
things too, is 14
No.
they can choose? No?
No. So what happens is the court looks at their maturity level and things like that. If they're going to consider what the child wants, but the child never gets to tell the court, I'm going to live with dad. I want to live with mom. There's interview processes that the court can have children undergo. I think it's horrible to bring a child in as a witness, but there is that. Sometimes it's necessary. It rarely happens in family cases to try to keep it out, but sometimes it's necessary. But then there's also parent coordinators. There's also reunification therapists, which I know you do a lot of that, or just therapeutic services that the mental health professional can offer. But I think what you really need to look at is, as a whole, what is going on? What are the dynamics of that family right now? And why is this child all of a sudden, because people automatically want to say it's parental alienation. Well, number one, a lot of times a parent causes their own demise with their child and they don't realize that. So that parent is causing that child to not look at it.
Yeah,
Now,
they're not
as far
helping the
as
situation.
what I tell my clients is don't ever be in contempt of a court order. It's never going to put you in a good light with the court. Your kid says, I'm not going to visit mom or dad. You encourage that relationship to the best of your abilities. Now, there's a difference in somebody being ordered to pick their child up from school. They don't go and then they say the child didn't come with me. They don't go then pick them up. So there's a lot of differences in family court that you have to look at. Why, what happened? What did you do to get that child into your custody? Now, there's also a difference with the age of the child. If you have a 3 or 4 or 2-year-old, you put them in a car seat and you exchange that child. If you have a 10, 11, 12 and upwards, sometimes those kids are bigger than a parent and they can't do it at that point. But you don't at the same point want to let a child say, I'm in control of this situation, because they need to have that relationship with both parents regardless of where they're at in life.
Right.
It's important. So as a judge, I think you need to look at, I know a lot of people start filing contempt motions against a parent because there's an order that you're supposed to exchange the child at certain times. And yes, if the parent is not at fault for this, should they be held in contempt? Maybe, maybe not. I mean, you have to, again, look at all the facts and circumstances. So I think those kind of issues go on a case-by-case basis. And then maybe it's getting a child involved with a therapist, having that other parent that they're saying they're not going to go to still maintain contact with that child through a therapist or a family member that they're both close with, where there's still that. Maybe
It's
not
like
an
options.
overnight, right. But then you get to a point where I've had cases where you have a 16, 15, 16-year-old. If you force it as a judge and you force an order without trying to get services involved first, the thing you're going to do is you're going to make a child run and you're going to make a child defiant and not obey anything. And that's still giving them the thought that I'm running this case, haha, I'm doing what I want as a kid. And they can't do that. But I think you have to look at each situation on a case-by-case basis and try to be creative in how you're going to resolve this issue so it doesn't continue.
So one of the things that you were mentioning is the services or things and some of the newer services out there or that might be being used more. So custody evaluations, full custody evaluations are giant reports with psychological testing and
They're
many
expensive.
people it's like what, $10,000 or something. They could be really. So a lot of courts are using the brief focused, which are, maybe 5 hours of work, and it's much more affordable, as well as it's focusing on a particular problem. Why is this particular problem happening? And a lot of people out there don't know that that's an option. It doesn't have to be, because they're like, we need a custody evaluation. I'm like, how about try this option, which is a lot briefer. You'll get the report faster and it's much more affordable. Right. And then another thing that you were talking about, which not a lot of people know about, is we have the cooperative parenting classes, which are great. We have the parent coordinator, which is, kind of a authoritative role over parents. But we also now have parent coaching, which is kind of like a blend of both, that has an authoritative role, but yet some coaching and teaching them about why we can't talk to kids like that and why this is not a healthy scenario. And that's something a lot of people don't know that's offered out there also. So as you're talking about these things, and you already talked about so-called teen discretion, which is, the 14-year-old saying, I'm going to decide. But you said that maturity's in there and there's other factors in there. So I think they don't have a rule right now about teen discretion.
No, they do.
What's that?
So the legislature has determined that it should not be a judge's role to order. They're not really allowed to order teenage discretion anymore.
Oh, really?
It used to be way more popular. However, if parents, because the whole issue with family court, parents have a super high constitutional right to decide what is in the best interest of their children. And that should always be at the top priority unless somebody has an issue that keeps them or prohibits or inhibits
so
them
it's
from
their
making
right.
that.
We have
But
to
if
try
parents,
to keep their rights.
If parents agree that we can have and the court always wants a default schedule in case somebody doesn't end up getting anything with this child. But if the parents ultimately agree that our child is of the age that we believe that they should be able to decide, are they going to spend more time with mom or more time with dad? And we agree to that. That can still go into orders. And that's more teen discretion. It's still a parent decision. The child never gets to come in and say, I'm taking teen discretion over this case, ever.
Really?
No. So that is
Well, I
never,
saw that somewhere.
yeah, so teenage discretion is more when the parents agree to it.
So
And
they use the teens'
they allow,
preferences or needs in the schedule making.
not
the
not
parents do.
necessarily in the schedule making, because at the time that teenage discretion is ordered by the court and agreed to, it has to be agreed to now by the parents and then ordered by the court. There would be a default schedule. So say you say, we're gonna do week on, week off, just to make this easy. And so mom has week 1, dad has week 2, and they alternate. What happens with teenage discretion is while that child's in one parent's custody for that week, say they decide, you know what, I really would rather stay a couple extra days with mom, or dad's going to this activity, I really want to spend a couple days with him and go to an activity and spend time with him.
Right.
The child would have that discretion to determine where they want to spend their time. But again, you don't see that a lot in high conflict cases because you can't get those parents, they're fighting. They both want that child only in their custody.
Right.
So that's a problem. So, but yeah, you can have teenage discretion, but it doesn't, what a lot of people probably think is that then the child gets total say, and they don't. They get a lot more
Do you
say.
think attorneys know that?
What?
That no, the child doesn't get to have the say if they go visit a parent or not.
I don't
Like,
think, I
no.
think it gets too heavily like relaxed.
Okay.
So that sometimes, and that's when you get them back into court, that's what I'm saying. That's why the court wants a default schedule, because in the event that one parent is persuading this child, don't go back. Then you have the issue, well, now we've agreed to teenage discretion, now I never see my kid again because
Right.
I thought that this would
Right.
work out better than it is. So there are so many issues, and that's the problem with family court. If you get a family initially, you're not done with them until those kids age out. It's not.
So like you become like their other aunt or uncle, like you're overseeing them
You do.
and their lives up until they're 18 or so years old if
You do.
you're still in there.
But I think the judges have to take a lot more time to really think about what's going on in these cases before they sometimes it seems like the judges don't really care about this family that's in front of them.
So how are you going to be different than a judge like that? What are you going to do differently?
My opinion for cases is that parents should always have the opportunity first to try and work this out. There's some judges that go overboard on that, where you go into their court and they're like, I'm sending you to mediation. Well, that mediation didn't work. I'm sending you to another mediation. And as a judge, that's not the way you're supposed to handle cases. You're there to make decisions when parents can't or when parties can't in a divorce. And so I think what you have to do is with the tough cases, you have to really look and read. That's one thing, as a judge, you're supposed to read those pleadings ahead of time and know what's coming in. And from reading those, you should be able to find out, well, you know what, there's this service available. I can order this. I'm going to order this and try it and see if this family unit doesn't get any better. You know,
Right.
so, I mean, that's the way I
But
would
actually
handle it
making
more,
the decision.
is that a lot of parents are not aware of what services are available, whereas a judge should, that's dealing with custody cases. And so as a judge, there's a lot more that you can do to help families.
Right. And I think I have to say a lot of attorneys out there are not aware of what's out there to
I
even
think
help.
the problem is, what I always tell clients when they come to my office is, I don't care about you or the other party, not to be mean, leave if you want. But when you have children involved, that is my priority. If I have a client that has issues and I can see from meeting with them, you're not able to make real good decisions right now. That's where I told you, I want them open to me, and I will help them start getting services that they can do, either substance abuse, treatment, mental health counseling, things like that, before they even get into court.
So you support
So
that for
they're
your own
starting it.
client?
I do, and I push that, because when they are in court, they can show the court, here, I have this many sober drug tests, I have this many sober, get them on SoberLink, get them on the little bracelets that tell if they're drinking or not. Because as a human being, do I want to place a child, even if it's my own custody, if they're not in a safe position? No. And so I think that's the big problem. And so I think that a lot of attorneys don't do that. A lot of attorneys, their mindset is, I win so many family law cases because I get what my client wants. Number one, there's no winner or loser in family law. It's a destruction of a family unit.
That's interesting because I hear that repeatedly
It is.
over and over. It's not, you don't really win.
If the best interests of the kids are met, then everybody wins. If those kids are healthy and okay, everybody wins. So from my perspective, it's that, you know, if you're an attorney taking a case on to only get what your client is hiring you to do and not looking at what is in the best interest of those children, you need to go in the different field because you don't care.
Right.
You have to, not sympathy. Sympathy does nobody any good. You have to empathize and you have to care about these families.
Right.
And as a judge, you can't so much as an attorney, because a judge, you have a certain position. You have to make decisions and orders that you are seeing in the best interest. But there's ways to do that where you put them on temporary orders, pending having them go see a therapist or having them go get some help they need.
Right.
To build that, to get them back up to where they need to be with those kids.
I think it sounds like all your years of working in this, you've seen what's available, you know what's available, you know what the options are. As you're in front of different judges in different courts, it sounds like you've seen different kinds of options work for different people. So you have this whole list of things in your head.
Right.
But so as looking forward, if after this, maybe after watching this video, somebody has some questions or wants your opinion or your point of view on something else, how can they best get in touch with you?
Okay, so people can call me at my office. The office number is 702-966-8390. I offer 30-minute free consultations. And I would go over anything with anybody. I try to make myself as available for them as I can, but I am a sole practitioner, so I'm in and out of the office a lot. But that's the best way. Also, they can email me. I'm pretty good at responding to emails, usually pretty timely. And that's Carrie, Kari, at Molnar, MOLNAR, familylaw.com.
Okay. Thanks so much for talking
Thank you
to me.
for having me.
I tell everybody I learn something new every time, and I really feel like if this process doesn't inform anybody else, it sure is informing me
Right.
on the different points of view that people have. So I appreciate it so much.
Oh,
Thanks so much
I
for
appreciate your help with this. Thank
coming.
you.
You're welcome. Have a good
All
one.
right. Thank you.